You will recall that during the prosecution case, I have on a number of occasions been critical of your colleagues who represent the other defendants. Basic rules, both of law and procedure, have been regularly broken.
Says who? Well, says Judge Gledhill, at the end of a fraud trial he'd conducted in London 3 years ago. His words were spoken there by an actor. It's unusual for a judge to be quite so critical about defence lawyers, the advocates who stand up in court and address the jury. But what's striking about the defence advocates in this case is that they weren't barristers, the lawyers who've traditionally done the advocacy work in the Crown Courts of England and Wales. They were solicitors.
One solicitor in cross-examination on 2 occasions addressed the jury directly. Another clearly had no idea what the rules of re-examination were. The jury were misled about one of the defendants' bad character until it was corrected by prosecution counsel. Some of your colleagues appeared to have little or no understanding of hearsay. The list goes on and on.
Now, it's fair to say that the 3 solicitors Judge Gledhill was complaining about immediately rejected his criticisms of their advocacy skills and complained in turn about him. A year later, the judge accepted that it would have been better if he'd given the 3 a chance to respond before criticising them in open court, in which event, he said, their conduct might have been seen in a different light. But this case illustrates a much broader issue, whether standards of advocacy in the criminal courts of England and Wales are high enough to ensure that trials are truly fair. As we'll be hearing from a leading member of the Court of Appeal later in this edition of Law in Action, there are concerns that threats to the independent bar may undermine our entire adversarial system of law. When I was a trainee lawyer more years ago than I care to remember, solicitors could represent clients in the magistrates' courts of England and Wales, but barristers were the only lawyers who could appear in the higher courts and address juries in criminal trials. Solicitors did the preparation work, tracking down witnesses and taking statements, while barristers specialised in courtroom advocacy. But in the 1990s, solicitors who'd done the necessary training were allowed to qualify as higher court advocates and do the courtroom litigation that used to be done by barristers. And why would a solicitor's firm want to do that? Judge Gledhill thought it all came down to money in the end. With legal aid being cut, these solicitors didn't want to share any of their fees with barristers.
The solicitors would therefore get both the preparation fee and the litigator's fee, in effect doubling the income from the case. I am well aware that recent reductions in the rates of legal aid have hit solicitors particularly hard. On a practical financial level, it must be sorely tempting to keep the trial within the company. I understand that. However, if the consequence is that an accused person is not adequately represented, it is simply not acceptable. Not acceptable to the defendant, and not acceptable to the public, as it is not in the interests of a fair trial, and therefore not in the interests of justice.
Is Judge Gledhill right to imply that a defendant represented by a solicitor advocate may be worse off as a result? That's a question I discussed with Professor Richard Moorhead of Cardiff University, who specialises in regulation of the legal profession. He said the question of whether solicitor advocates overreach themselves is hotly debated.
Well, the bar says that they do, and the Law Society says that they don't. There isn't any independent evidence on it. The economics suggest that there would certainly be a temptation for solicitors to do that sort of thing, either because they want to get them the work and keep the money, or because they want to develop the experience. But there isn't any direct independent evidence on it.
Do we have any evidence about the quality of solicitor advocates as against barristers appearing in court?
There's very little. There is a research project which I was involved in which assessed barristers and solicitors in a variety of ways to look at the quality of their advocacy and the knowledge that they would need in relation to advocacy. And in broad terms, you couldn't see very large differences between the two groups. But it was a small study, and there's been nothing much other than that.
But presumably, if solicitors are not in court every day, they're simply not going to build up the experience that a barrister would get.
Ordinarily, they would have less experience of advocacy. It would depend on how their work is managed. As solicitors' firms get bigger, then it's possible for them to get staff internally to specialise in advocacy. But normally that would be right. I think there is an interesting question, actually, about how much trial experience, particularly junior advocates, get. There aren't actually that many trials to go round.
Now that's a problem because it's going to be more difficult then for young advocates, whether they're barristers or solicitors, to get the experience they need if they're going to be able to perform at a higher level.
Absolutely right. Absolutely right.
Is there any answer to that?
The answer, I suppose, is that the more that the regulators think clearly about regulating the quality of advocacy, the more they'll start to grapple with these quite significant issues. Up until now, we haven't really thought very concretely at all about the quality of advocacy. It's been one of those areas that's been left unscrutinised by the regulators, really.
Professor Richard Moorhead, doing the best he can on the research that's available. But dig a little more deeply, and you'll find that the real division is not between barristers and solicitor advocates. It's between self-employed independent practising barristers on the one hand and lawyers who are employed by law firms or public bodies on the other. And one of those bodies is the Crown Prosecution Service, which is responsible for bringing the vast majority of cases before the criminal courts of England and Wales. To save money, the CPS is increasingly using its own in-house Crown advocates, rather than briefing outside barristers on a case-by-case basis. Speak to barristers in private practice, and they'll tell you they don't think very much of in-house CPS lawyers. Sometimes Crown advocates aren't as well prepared as they should be, because they tend to keep office hours, unlike self-employed barristers who work from home late into the night. Some in-house advocates, they say, are a bit of a pushover, allowing defendants to get away with less serious charges. 3 years ago, the inspectorate that assesses the work of the Crown Prosecution Service found significant weaknesses in relation to trial advocacy. The work done by in-house trial advocates needed substantial improvement, the inspectorate added, particularly in regard to cross-examination. Have things got better? Michael Fuller, the former Chief Constable of Kent, now heads the inspectorate. He commissioned a follow-up report and published its findings earlier this year.
What we found was that the quality of advocacy had not improved in the way we would have expected, even though there had been significant financial savings over the 5-year period since the last inspection was conducted. And we're talking in savings in the region of £26 million, so very significant.
I'm not very surprised about that. I would have thought if you're paying less, then quality is going to go down.
I don't doubt the commitment at the top of the CPS to improve the quality. What challenges the Crown advocates have faced is actually getting that contested work that would actually develop their skills, their experience and confidence so that they could prosecute as well and as confidently and as competently as the observations and the advocacy that was seen amongst members of the self-employed bar. We felt there was a slight difference in quality where you saw better quality amongst the self-employed bar, particularly in the Crown Courts. And we saw extremes where we saw some excellent performance, but also some not so good performance. In some ways it was quite disappointing that we hadn't seen the improvements in quality that we would have hoped for.
What sort of mistakes were they making?
Well, a lot of the mistakes were silly and quite small slips. There was one particular example of the otherwise competent Crown advocate was let down by a silly slip when he carried out his opening speech, which actually led to the jury being discharged. And I think the more serious is where the mistakes actually lead to a prosecution failing or being thrown out as a direct result of those mistakes, which could have been avoidable.
See, the problem is that if CPS advocates do badly, the defendant is likely to be acquitted, and that may be a miscarriage of justice. It's a serious matter, it's a serious concern.
Yes, I think it should be seen in that way, that if the prosecutor makes avoidable mistakes and doesn't prosecute competently, then clearly justice is denied for victims of crime.
Guilty people are going to go free.
And guilty people could go free as a direct result. And that has serious consequences for confidence in the whole of the criminal justice system. Clearly what we want is professional prosecutions conducted by people who are trained, confident and competent in their advocacy.
And that's achievable in the future, even if it hasn't been achieved in the past?
Yes, I mean, I feel very optimistic. I think it's realistic and achievable. You could develop competent and confident advocates, fewer in number, that are better trained. So I think that's quite realistic and achievable.
Michael Fuller, who heads the Prosecution Inspectorate. In response, the Crown Prosecution Service told Law in Action it was addressing the problem of advocates whose work had fallen below acceptable standards. in-house advocates were no less competent than those from outside, it added. And this was a CPS response to the most serious charge of all, that guilty people were being acquitted because of avoidable mistakes.
We do not accept that significant mistakes are being made. The Director of Public Prosecutions has long been working to embed a culture of high-quality in-house advocacy, of which the CPS can be proud. Much of the detail of this report recognises that. In the past few years, major changes have been brought into the CPS to improve the quality of advocacy consistently across England and Wales.
But how do you measure the quality of advocacy? In response to concerns of the sort that Judge Gledhill was outlining earlier, the three main regulators responsible for barristers, solicitors and chartered legal executives have recently established a quality assurance scheme for advocates in England and Wales. When it starts next year, criminal barristers, solicitors and legal executives will be assessed by the judges before whom they appear and accredited at 4 levels. You'll be allowed to address a magistrate's court if you're a level 1 advocate. You'll need to progress to level 4 before you can do the most serious cases in the Crown Court. But tensions between barristers and solicitors with advocacy rights are still running pretty high. Sandeep Bhatia is a solicitor advocate who runs his own law firm in North London. He says he's looked down on by the barristers he faces in court. So I invited him into the Law in Action studio with Baroness Deach, who chairs the Barristers Regulator, the Bar Standards Board, and to make sure that we don't ignore the public interest in all this, we were also joined by Elizabeth Davis, who heads the consumer panel set up by the overall regulator, the Legal Services Board. First, Sandeep Bhatia. Earlier this year, he wrote a magazine article about his experiences.
I wrote that article because I went at the beginning of the year to the Law Society, and they were setting up a division for advocacy services. And there were many figures who came and talked to some judges who basically said that whether you're a solicitor advocate or whether you're a barrister, the standard of your advocacy is all that's important. And I felt inspired. I wrote a little blog and tweeted it. And I had tweets from one particular barrister saying, solicitor advocates, bad idea.
And is this typical?
Yes, I think there is a very real hostility by the bar towards solicitor advocates. I can understand that because obviously it means diminishing work going to the bar, and nobody likes to see that happen to their particular profession. But I think there is a feeling of protectionism and a sense that solicitor advocates should not be allowed to encroach upon the traditional territory of the bar.
Ruth Deach, it is understandable that if barristers are finding the bread being taken out of their mouths by somebody from a profession that hasn't traditionally done this work, they're going to be protective.
Well, inspiration isn't enough, and one tweet doesn't make a summer. I don't know if barristers have anything in their minds other than expecting everyone in court to be up to the same level that they are. And as far as protectionism goes, everybody's in trouble because of the cuts in legal aid. But what we all want is for every advocate to be assessed at the same high standards by a judge and to have plenty of training.
Elizabeth Davis, where does the consumer stand in all of this? Is the consumer going to be better off with a barrister or a solicitor advocate, or isn't it as simple as that?
I imagine the consumer and most consumers listening to this programme today, a sizable percentage are going to be really surprised to even hear that there is a distinction between a solicitor advocate and a barrister. You know, that kind of notion of professional titles determining quality is going to be beyond most of us. So I think where the consumer stands in all of this is, how are we going to ensure that consumers have access to good quality criminal advocacy services? It is incredibly difficult to make that quality judgment. Some of that's down to the specialist nature of advocacy services. This isn't an everyday experience for most consumers. There has been some work looking into criminal advocacy that found that whilst advocates performed well at the simplest and at the most serious accreditation levels, there were real concerns over performance levels kind of in the middle, if you like, lesser Crown Court trials.
Ruth Deach, that's right, isn't it? Some barristers are good, some barristers are bad.
Well, that's why we're introducing the quality assurance scheme for all advocates, which is bringing the solicitors and the barristers together. And we will get the evidence over the next couple of years. But you must remember there's an awful lot of information out there for the consumer who has access to the internet or indeed a library, because the details of every barrister, plus their recent cases, are up there on the internet, and there are great big directories in every library telling you what the barristers do and where to find them and how to contact them.
And when this quality assurance scheme comes in, will the client be able to tell what level of accreditation an individual barrister has achieved?
That's absolutely essential, that the client knows whether they're dealing with a solicitor who may not be accustomed or cannot do full trials, or whether they're dealing with a barrister and at what level.
Sandeep Bhatia, an advocate is bound to be better if he or she is doing advocacy full-time, and you as a solicitor advocate running a busy office can't devote all your time to advocacy.
I think that when I come to do a case, and I speak for myself personally, I probably over-prepare it. I also know my limits, so I won't take on cases above a level I feel that I cannot handle. I do feel there is a position for the specialist bar to take on cases at a higher level.
But the real problem is with training, because solicitor advocates do not get the same training as barristers do, and that's not your fault, Sandeep Bhatia. It's the fault of the profession to which you belong.
I dispute that. The reason being that most solicitor advocates, before they become solicitor advocates, they cut their teeth in the magistrates' court, appearing there on a daily basis in front of benches, putting forward arguments, dealing with clients, putting in pleas, doing some Crown Court work. So solicitors, before they can become solicitor advocates, either have the requisite experience and therefore are allowed to become solicitor advocates, or they receive additional training and they go on additional training courses before they're passed off as being fit enough to become solicitor advocates.
Elizabeth Davis, it looks to me as if both the barristers and the solicitors are trying to do the best they can with the limited resources that the government is allowing both for prosecution work and defence work. Do you have concerns about the way it's all going?
We've welcomed the introduction of the Equality Assurance Scheme that Ruth referred to there, and Ruth talked about the importance of consumers accessing information. I think one of the challenges is we are seeing that consumers are not shopping around. So one of the kind of real issues, if you are thinking of this from a regulatory perspective, is what are we doing to actually protect consumers? What are the quality assurance processes so that actually, irrespective of where you go, you are being guaranteed a level of competency that is exactly what you should expect?
I mean, is the answer fusion of the profession, fusion between solicitors and barristers? Is that the direction you'd like to see things going to, Sandeep, where it doesn't matter whether you're a barrister or a solicitor?
I think that a degree of fusion at the lower end of the profession, especially so far as criminal matters are concerned, is inevitable. It's happening already. This is as a result of what happened a few years ago when the bar negotiated a better deal for advocates than litigators, solicitors who traditionally prepared the case. So solicitors' firms have reacted by bringing more of the work in-house, and I think given the legal aid cuts and the current situation, that's a process which will continue.
Ruth Deitch?
Well, flexibility is on the agenda, but fusion, absolutely not. As I've said before, in every jurisdiction you find there's a natural division eventually between advocates who are court-facing and non-advocates who are more client and office-facing. But the point about the separate bar is the cab rank rule, namely they take every case that comes along, no matter who it is, a paedophile, a terrorist. The barrister is not identified with the client, but will stand there and will challenge the government and will take on every case, not because the firm says they may or they may not, and I know that solicitors' firms have such policies. The barrister will, in the end, always stand up fearlessly and do the job, and is trained to do exactly that with minimum overheads.
Elizabeth Davis, Baroness Deitch says you're better off with barristers.
I think this comes down to the whole issue of can you demonstrate competence? Can you do the job? And I think anyone who can demonstrate their competence to practice should be permitted to provide legal services to consumers under appropriate supervision. And I do think professional titles are going to start to lose their meaning to consumers. And what you will see is a diverse range of providers, not just the traditional branches of the profession, being authorised to do the same work. And all of it will come down to competency.
Elizabeth Davis, Baroness Deitch and Sandeep Bhatia. As I mentioned earlier, the quality assurance scheme for advocates will depend on assessments by judges of the advocates appearing before them. Some judges have embraced the scheme as an opportunity to raise standards. Others are accepting it reluctantly on the basis that nobody else is better placed to assess quality. But one judge is speaking out against the quality assurance scheme, Lord Justice Moses from the Court of Appeal. He said it would damage the delicate and subtle relationship between the advocate and the trial judge. He told me why.
The purpose of a trial is not an exercise in judging the quality of advocacy. And what this system does is pervert the purpose of the trial process. Take an example of a young advocate with a difficult client and a difficult case, and a judge who thinks that he understands what the point is and yet gets it wrong. Well, it requires bravery and courage to stand up to the judge and say to the judge, no, you've got it wrong. Now, what is the young advocate to do if on that particular trial he's gone to the judge, as he will be required to do, and say, I wish to be assessed to see whether I can move up a grade or not?
But there is a problem, isn't there, if you're going to broaden the eligibility of people to appear in court. You're going to have people who have not been trained through the system of barristers. They don't have the support of the Inns of Court. You need some way of making sure that those advocates are up to scratch.
Of course you do. And the purposes of the quality assessment scheme are entirely laudable. You wish to maintain and improve the standards of advocacy. But you don't do that by marking. You do it by a system of training, a system of apprenticeship, a system of learning that continues throughout your professional career.
You're not saying that advocacy should be confined to barristers, are you?
Certainly not, no. I think it's a very healthy thing that there are higher court advocates that come from the solicitor's profession as well as the bar. But what you must not lose is quality, and it's therefore very important, and the solicitors understand it, that their training is as good as that for a barrister.
Do you have concerns about the way all this is going?
Yes, I do. If you have certain types of advocate who work in a firm who are concerned about their promotion and their position in a firm, the danger, it's not necessarily so, is that that quality of independence will go. Let me illustrate it in this way. When you're appearing in a criminal case, the best way to hone your skills is to appear sometimes for the prosecution and sometimes for the defence. In that way, you understand the pitfalls in pursuing both. If you appear because you're employed by a firm or employed by an institution such as the CPS, you lose that ability to learn by reason of the fact that one day you're appearing for one side and another day for the next. And what worries me is that without a cadre of independent advocates, some of those qualities of independence will be lost, and they seem to me to be absolutely vital for the success of the profession, for the success of the law, and indeed for the judiciary.
For the success of the judiciary, because those advocates, under our system, will become the judges of the future. And what are your concerns then about the judges of the future?
Well, you just have to look at the great judges of the past and of the present. Where did they learn their skills? Where did somebody like Igor Judge learn how to become a good judge?
And Lord Chief Justice.
And Lord Chief Justice, or Lady Justice Hallett, or Lady Justice Rafferty. Where are you going to find people of that quality in the future if they have not had to struggle as independent advocates in the past when they were young?
Lady Justice Hallett, who is in charge of training for the judiciary, is concerned that judges need more training, that they may appear to be out of touch. Does she have a point?
However much judges, and I am one of them, have tried to persuade people that they are not out of touch, the public won't listen and certainly won't appreciate it. And that seems to me probably a fault of the judiciary, that they have failed to give the appearance of understanding what life is like in the language they use, in the attitudes they display in court. You can't train somebody in empathy, in understanding, but you can train them in how they display their understanding.
And does that mean that we need to have a judiciary which appears to be more representative of the community that it judges? In other words, we need more women, more ethnic minorities, more young people, people from different backgrounds.
And of course we do. The judiciary must give the appearance of representing the society it serves. And it is therefore very important that the judiciary, in their diversity, look as though they're representing the society with which they deal. The judges have been saying, oh, it'll all happen in the future, don't worry, it's going to come. Well, I'm afraid they've been saying it for far too long and it's too late. It's really urgent and it's got to be done as soon as possible.
But this brings us back to where we started, which is the problem that because of the way the system is working, the only way you're going to join the bar these days is if you've got a private income and rich parents.
It's completely disastrous. That's what's so depressing about the quality assessment system, because it targets upon the most vulnerable part of the advocates, those who are working for very low reward and trying to get the work. And it's really important that we create a means of diverse entry into the profession, be they solicitors or barristers. The last thing we want is wealthy people protected by their wealth from the difficulties and vicissitudes of life on the street as a young advocate.
But doesn't it all come down to money in the end? If the system is under financial pressure, it's got to cut corners, and there's no way in which the quality that you are seeking can be achieved if work is having to be done more cheaply.
Everybody who says that corners have to be cut must remember if they were accused of an offence of which they were not guilty, what would be the first thing they would want? They would want a brave, independent advocate to represent them. And if they just no longer exist, then the system is over, it's finished.
And that's what you fear?
That's what I fear. I don't think proper adversarial system of law, which the public will trust, can survive without independent advocates. And they've got to start somewhere. If you take the work away from them, if you don't pay them anything on which they can live, then how are they going to exist?
A depressing conclusion from Lord Justice Moses, I'm afraid, but then he always was a powerful advocate.
Thank you for listening to this edition of Law in Action. It was presented by Joshua Rozenberg and produced by Wesley Stevenson.